Hello, everyone, and welcome to today's Lunch and Learn webinar, Hot Topics in Tenant Rights. I'm Patricia Narciso, Director of Strategic Partnerships at Community Legal Services in East Palo Alto. We're thrilled to have you join us for today's exciting topic. First, a few important details. For your participation in today's webinar, you'll be eligible to receive CLE credits. In order to get your certificate, you will need to sign up for the credit by clicking on the link that we'll provide at the end of the webinar. We will follow up with you to administer a participant survey that's required by the State Bar. Once that's completed, we'll send you your continuing education certificate. We want to take a moment to express our sincere gratitude to CLESPA's lead annual sponsors. These companies and firms provide vital financial support that makes possible our community work and our pro bono membership services in housing, economic advancement, and immigration. On behalf of our staff, our board, and the community we serve, we thank you so much for your enthusiasm and your participation in our mission. In addition, we want to give a special shout out today to Finnegan for partnering with us to provide tech support for this webinar and also to provide the introduction of today's distinguished speakers. Sincere thanks to Latanya Bunton and Sabrina Greenewald for your expertise and collaboration. And now I'm happy to have the opportunity today to provide an introduction to Ming Tao Yang, who will kick off our webinar by introducing our speakers for today. Ming Tao Yang is managing partner of the Palo Alto office at Finnegan. Ming focuses on litigating patent and trade secret disputes, negotiating intellectual property license agreements, and advising clients on invalidity proceedings. He leverages his extensive experience to negotiate and resolve patent and trade secret disputes while formulating creative and strategic business solutions. Ming also devotes time to pro bono matters in support of people in need in Bay Area communities. Community Legal Services in East Palo Alto was proud to feature Ming recently in a video about his successes in safeguarding tenants' rights through his pro bono participation with our organization. And now I'm pleased to turn the mic over to Ming Tao Yang to introduce today's speakers.
Thank you, Patricia. Good afternoon, everyone. I'm Ming Yang. It is my pleasure to welcome and introduce our presenters, Jacqueline Ramirez and Keith Otten. Our firm has worked closely with CLESPA on tenant right matters. On behalf of Finnegan attorneys, we cannot thank CLESPA enough for working closely with us on negotiation, court proceedings, and jury trials. Many of you are helping our communities, our families in the communities, and individuals in need. From our own experience, working with CLESPA not only helps people in need, but also sharpens your litigation, trial, client counseling, and negotiation skills. I'm honored to introduce our speakers. Our first speaker is Jacqueline Ramirez. Jacqueline is a member of CLESPA's housing program. Jacqueline earned her JD from Santa Clara University School of Law. She's a native Spanish speaker, born and raised in Tijuana, Mexico. Jacqueline's passion and commitment for social justice has been focused on labor and housing rights. Jacqueline has a long history of serving our communities. Prior to entering law school, she advocated for workers' rights in the Bay Area and in El Salvador, where she worked with an international human rights organization. After obtaining her JD, Jacqueline took her passion to civil rights in housing advocating on behalf of tenants who had been victims of housing discrimination. Prior to joining CLESPA's team, Jacqueline was part of the senior leadership at one of Silicon Valley's largest service providers for people experiencing homelessness, where she led a team focused on providing clients with housing and employment supportive services. It's also my privilege to introduce our second speaker, Keith Ogden. Keith earned his JD in 2010 from UC Hastings College of Law, where he received a public interest certificate and was a member of the Pro Bono Society. While at Hastings, Keith interned with Bay Area Legal Aid's housing team and the Lawyers Committee for Civil Rights. He brought his commitment to social justice to CLESPA in 2011. After completing a Breach Fellowship with Housing and Economic Rights Advocates, also known as HERA, where he assisted clients on loan servicing and loan modification matters. His initial housing work at CLESPA focused on foreclosure prevention for low-income homeowners. Since 2015, Keith has practiced in tenants' rights, representing tenants in eviction and habitability cases. He also has litigated several fraudulent eviction cases. Keith collaborates with community partners to advocate for local policies and at preventing and creating affordable housing and creating stronger tenant protections. He currently serves as an intern co-director of CLESPA's housing program, helping lead the team's multi-pronged approach to tenant protections and eviction defense. Welcome, Jacqueline and Keith. The floor is yours.
Thank you. Thank you so much for those lovely introductions, Ming, and good morning / good afternoon now to everybody, and thank you for joining us. So before jumping into the substantive matters here, I'm just going to give a brief overview of what we'll be reviewing. There's going to be 3 areas that we're going to focus on. The first is eviction tsunami, fact or fiction. Next is the shifts in the tenants' rights landscape. And last but definitely not least, what you can do to help this work. Keith?
Thank you. And again, thank you, Ming, for the lovely introductions, and to everybody here that's supporting. And thank you for the attendees and folks listening on the recording for taking the time to do so. To get started, eviction tsunami, fact or fiction, I want to take us back 2 years, a little bit more than 2 years, to spring of 2020, when, because of COVID-19, businesses were shuttering and were forced to shutter. And as a result, many people were temporarily and or long-term without work. And this created an initial urgency for tenant protections, because many of the people most impacted were tenants most at risk of eviction as well. Fortunately, San Mateo County and the city of East Palo Alto, through local advocacy that CLESPA and others, including Faith in Action and Legal Aid Society of San Mateo County, were involved in, got laws passed that went into effect right at the beginning of April 2022 that put a moratorium on evictions for non-payment of rent due to COVID impacts. So that was great, because the state did not act at first. The state did finally take action, and the next slide will show a little curve that sort of gives an idea in picture form of the strength of those protections. Initial protections went into effect in September 1st, 2020, and those allowed tenants with COVID impacts to sign a declaration that they were impacted by COVID, job loss, medical bills, other impacts that directly impacted their ability to pay rent. And also required that they pay 25% of the rent as well. And so CLESPA and other partners through rental assistance funds worked to both ensure that tenants were signing the declarations if they applied to them, if they indeed had a COVID impact, and to assist with the 25% if the tenant indeed had no income at all and no way to pay. There were some tenants who were working very part-time and might have had ability to pay 25%. So fast forwarding, the protections got stronger, and the main strengthening went into effect February 1st, 2021, and really went into effect with the state rental relief in March of 2021. That's a program that lasted through March of 2022, so a little over a year, and has paid tens of thousands of dollars on behalf of tenants to make landlords whole where tenants were unable to pay rent due to COVID impacts. This saved many, many, many tenancies and created the stability for many families. However, as you can see in the bell curve, those protections ended, and most starkly in April of 2022, where the rent relief program closed, meaning they did not accept any more applications after midnight, March 31st, 2022, and where for tenants who were unable to pay April rent and beyond, there were no protections. For tenants who still had applications pending for rent before April, that was due before April, through the COVID-19 rent relief program, indeed, there were still protections, but those protections, even those protections, ended more or less at the end of June 2022. And so as a result of that, and one other factor that's important here is that in San Mateo County and East Palo Alto, the local laws were superseded by the state laws, and although local efforts were made to try to get San Mateo County Board of Supervisors and other local leaders to take action that might be able to provide some additional protection after April 1st, those did not take place. It was complicated by state preemption rules. However, in other cities like Oakland, San Francisco, the initial laws were written to survive preemption if and when the state laws ended. And so in those jurisdictions, there are still protections, but not in San Mateo County. And so let's look at the next slide. Oh, sorry, not the next slide. We're going to look at what I was going to get to in just a second. So Jackie's going to take it over now. Thank you, Jackie.
Thanks, Keith. Yeah, so with the end of those protections, we're seeing the eviction tsunami that we're currently in. And contributing to that eviction tsunami are several myths. So I'm going to be going through those kind of rapid fire on what some of those larger myths are that are contributing to the eviction tsunami. So myth number one, that all pre-April 1st, 2022 rent is completely forgiven. So the reality of that is that the eviction moratorium did not mean indefinite or permanent debt forgiveness. Landlords can still absolutely evict or sue for back rent that's owed. Myth number two, that rent through June 30th, 2022 is forgiven. And this comes from that very last extension that the state did. And unfortunately, that's also not the case. And landlords can evict or sue for back rent. Myth number three, tenants can still access state rental assistance through the Housing is Key program. The Housing is Key program is that state rent relief program that Keith mentioned a few slides back. And the reality is that you cannot apply for the first time or ask for additional assistance since April 1st, 2022. If you had a completed application by March 31st, 2022, it's possible that that's still pending and being evaluated by the state, but you cannot still apply for the first time now. Myth number four, landlords cannot evict for the rent that went unpaid during the pandemic. Again, there was not a full forgiveness of debt accrued during the pandemic, and landlords can still evict or sue for payment of that back rent. One thing to note here is that generally there is a 1-year statute of limitations to evict someone on the basis of unpaid rent. So for older debt, the landlord can still sue in a civil claim for that. Myth number 5, that landlords must provide additional time for tenants to pay back rent. The reality is that they do not have to do this, and the only kind of notice they have to give is a 3-day notice to pay rent or quit. And once those 3 days are expired, the landlord can proceed with unlawful detainer or eviction. So more about realities with Keith.
Thank you, Jackie. Yeah, so all of this that we've described in terms of the ending of the protections, both statewide and the fact that there's no extension of protections locally, means that in recent months, we've seen a very large uptick in eviction activity. And this graph compares, or this bar chart compares 2019, so pre-COVID, to 2022. And I should just add that essentially any year pre-COVID would have been around the same as 2019. Things were pretty steady state for most of the time, little dips and rises here and there. But what we see in 2022, June through September, we've never seen quite the likes of this before. About a 250% increase in number of cases, and largely representing eviction cases. So what does this mean for tenants? Evictions are the top threat, and that means that for CLESPA, that is our focus. Next slide. So mandatory settlement conference needs, and I believe a few of you out there, and perhaps people listening to the recording, have been assisting with the mandatory settlement conferences at the San Mateo County Court that happen every Tuesday morning. And deep felt gratitude for everybody who has been assisting and continues to assist. Because of the large increase, the need for pro bono attorneys to assist at those conferences has spiked, and pro bono attorneys have heeded the call, which has been amazing and wonderful. What are mandatory settlement conferences? The way that San Mateo County has their eviction process set up is that every case, a few days before it's actually set to go to trial, the parties are called in. They can attend currently by Zoom, by phone, or in person, but are required to attend for the purpose of attempting to see if a settlement resolution of their case can be reached. And so many times landlords are represented by attorneys, and most of the time tenants are not. And so our clinic fills that need to provide pro bono tenants with limited scope representation for the purposes of advice and settlement negotiation assistance. Many of these cases, if not most, are simply non-payment cases right now. So we are seeing a lot more cases than in the past where clients are likely not going to be able to stay in the housing. And this means because of the high increase and the need for, well, let me back up, I should say, so many times the negotiations do include or focus on counseling clients and trying to reach a deal that will allow them some time to move out. And at the same time, unfortunately, that's more common than it was before because of the high number of cases that are simply for non-payment. What does this mean for tenants and for CLESPA? Let's look at the next slide. It means that we really have had to focus over the last 5 months, even a little bit before that, even going back to starting in around April, but certainly starting in June, July, focus on a few different things, but chiefly on just eviction defense and trying to, if there were cases that came through the door, which there have been some, where early intervention was possible, to focus on that as well. But where any kind of immediate threat of eviction, whether it's a 3-day notice or another notice for eviction or an actual unlawful detainer complaint or the mandatory settlement conference, which is just a few days before trial, that has been our focus. And what that means is that cases that we were typically handling before, we've had to put a pause on for right now for the most part. And those include cases that do revolve around habitability, which means cases where perhaps the landlord isn't fulfilling their obligation to create, to maintain a house that's healthy and safe. So examples can be lack of heat. It can be pests, rats, cockroaches. It can be a hazardous electrical or hazardous mold situation. Fortunately, there are some self-help materials and resources that we're able to point people to. But what's interesting, especially in East Palo Alto, where we do a lot of our practice, there is a petition process that's outside of the courts, because East Palo Alto has a rent control program and a rent stabilization program. There is an administrative process where tenants, if the landlords are not being responsive, can try to petition to the city and have a hearing, and more of a quasi-judicial hearing, not in front of a judge, but in front of a hearing officer. Those are great opportunities in the past for CLESPA, for CLESPA even to supervise law students and work with on that type of case, and or to work with pro bono. And at the current time, our capacity has been very limited on that. Harassment, discrimination, even rent increase cases, we've also been providing self-help materials and information. Fortunately, on rent increase cases, there are some really great statewide available tools, and I think Jackie might speak briefly on that momentarily. Next slide. All right, so we're going to take a little bit of a shift right now away from sort of the eviction tsunami, which we are in currently, but we foresee a day where that won't be the case. And we want to talk now sort of a little bit more prospectively to highlight some shifts in the tenant protection landscape that interestingly actually went into effect by state legislation, landmark state legislation in January 2020, and were quickly superseded by the COVID pandemic and the legislative responses on the local level and then the state level. So this was again a historic statewide law passed a few months before the pandemic, but then COVID specific protections became the relevant law. But now with the end of those COVID specific protections, what's called the TPA, or the Tenant Protection Act of 2019, is now paramount. So we're going to speak now a bit about this law. I'm going to speak a little bit about who this law does protect and who it doesn't, and then Jackie's going to speak a little bit about what the protections are, and I'll dovetail onto that as well. This was a very, very big deal, because before this law, most tenants in California had virtually no protections of the type that we're going to speak of in a moment. The only exception to this were tenants living in rent programs in cities, rather, that, and I think maybe a county or two that had rent stabilization programs. So San Francisco, Oakland, East Palo Alto, some cities down in the LA area, a few more in the Bay Area, about 15, maybe a little bit more than 15 throughout the state. But otherwise, tenants did not have any protections. So before we get to who this does protect, this new law, just a few notes that the law still does not protect tenants living in most single-family homes, and specifically single-family homes that are owned by individual landlords who are not corporations, who are not real estate investment trusts, who are not LLCs. if a family is living in a single family home of that nature, they are not protected. Also new construction, and this is a rolling date. So at any point in time, you just look back 15 years. If the home was constructed in the last 15 years, then the law won't apply. All right, next slide. Who it does protect? Almost everybody else. There are still some other exceptions for, of course, folks that are living in protected rent stabilized jurisdictions, like I've already mentioned, because there the local laws will be paramount. Also, folks who are living in subsidized affordable housing units may get some protections, but may have their own protections based on state and federal law. But otherwise, basically everybody else is protected. And this is a big deal. This is millions of tenants across the state who before January 1st, 2020, did not have protections. So now we're going to talk a little bit about, I believe we're going to talk a little bit about what those protections are. And I'll turn it back over to Jackie.
Thanks, Keith. So there's two main protections that the TPA affords people. One is rent caps and the other one is just cause. I'm going to talk to you about the rent cap protections. So in any 12-month period, a landlord can only raise the rent by 5% plus the consumer price index for that year, or 10% max, whichever of those two is lower. So the consumer price index changes annually. Right now, because of inflation, unfortunately, the 10% ceiling is the applicable amount. Again, this changes from year to year depending on that consumer price index, and sometimes even from region to region or county to county within the state. So if you want to find out what the current max is for where you live, there's a great tool called tenantprotections.org. And they have a really cool calculator on their website where you could just put in your zip code and it'll tell you exactly what the CPI is for that year and then what the max is for the rent increase that a landlord can give. Keith?
Great. So now we're going to talk about what are typically called in the law just cause for eviction protections. So just to take a little bit of a step back, without these protections, and so this would go for many families living in single family homes, this would go for folks living in new construction, 15 years or newer. It also actually would apply for to tenants who have not lived in their housing for for more than a year, rather. And it applied pretty much across the board before 2020. And that's to say that if there's no just cause for eviction protection, then a landlord would have the right to give a eviction notice, usually a 60-day eviction notice, in some circumstances shorter, but usually 60 days. And that would just say that you need to be out by X date, and that's it. Now, under the TPA, there are some very specific protections. So I believe, is there a next slide on this one? No. So just to describe to you all a little bit about this. First of all, if a tenant does violate the lease by, for example, not paying rent, violating a material term of the lease or other violation that's considered a lease violation or a violation of the law, then they are not protected. That's called just cause, basically. The landlord has a just cause or a good cause for the eviction. And like we said earlier, most of the cases we're seeing right now are just cause for eviction cases where there's been non-payment of rent. However, there are other laws that passed in the Tenant Protection Act, and those say that the landlord can evict for a few other reasons too. And these are interesting to and important to kind of know about, and certainly will be important in the coming year and years. And to describe these is to say that a landlord can also evict for a just cause where the tenant is not at fault. So the tenant didn't do anything wrong. They didn't allegedly fail to pay rent or breach the lease. It's simply that the landlord is stating that they have one of the allowed for reasons where the tenant's not at fault, but they still can evict. And those include the landlord saying that the owner is going to move in. Those include where the landlord says that they're going to demolish the unit, or the owner is going to demolish the unit, or where they say they're going to do substantial renovations that require permits, so bigger projects, or that they are going to withdraw the unit from the rental market, take it permanently off the rental market. So they're not going to rent it anymore. So a landlord can issue, usually it would be a 60-day notice. Again, in some cases it can be shorter, but normally a 60-day notice that states very specifically the cause that's been enumerated by the law is one of those four. But otherwise, the landlord rather cannot just say you need to be out in 60 days. They have to apply one of these causes. And I think that's plenty of information on sort of the state of the California just cause law at this point. What's interesting to note is that there are some holes, according to advocates, some situations where tenants are at risk still, and maybe at risk unnecessarily so. And those involve cases where the landlord has declared an intent to renovate, but that's not so clear or so certain. And so one example here is a push that some local advocates around the state have started in different jurisdictions and may gain ground at the state level even in the future, may not, but to require that landlords have permits, at the onset of the eviction process. The other is, rather than just have the law, which currently says for an owner move-in, that the owner rather says that they intend to move in, but actually have a requirement that they do move in. East Palo Alto has this where the landlord is required to move in for at least a year, and other jurisdictions may require even longer. So there are some holes that advocates are looking to plug on behalf of tenant groups. We have a group even locally in San Mateo County that's doing a lot of work around this, and we partner with them from time to time. And then this is actually a perfect sort of segue to our third sort of section, as Jackie introduced at the very beginning of our presentation, which is different ways you can get involved. And as you've been listening, I'm imagining that you've thought about ways that you might get involved, things that you might be interested in. And so hopefully some of the things that we're going to speak to over the next few minutes will reinforce your imagination around that or spark your imagination anew around that. And we encourage you to be in touch with us following this at any point to start those conversations, or as we send out, as we do through our pro bono networks, calls for pro bono attorneys to be on the lookout for those as well. So what can you do? So as we talked about, I think this is for Jackie actually, and then I'm going to talk about a few more in just a second. So Jackie, take it over.
Thanks, Keith. Yeah, so what you can do, and there is plenty. So the first thing is you can represent a client in a weekly MSC negotiation. And just as a reminder, MSC is our mandatory settlement conference. Those happen every Tuesday in the morning. And this is an opportunity for tenants who are experiencing an eviction to meet with a landlord and try to negotiate a settlement to both avoid having to go to trial as well as avoiding an eviction on their record. So as context, in the United States, an eviction is filed every 4 minutes. Most landlords in those evictions are represented, but even those that aren't often still hold an advantage because it's not their first time filing an eviction, so they have some familiarity with the court processes. Studies showing that in jurisdictions where tenants have a right to counsel, which we are not one, but just to provide some context here, in those jurisdictions where there is a right to counsel, there are far less orders for evictions being granted, and there's more favorable settlement agreements for tenants. So it's right to assume that a tenant that's represented is going to fare a lot better in these types of negotiation conferences. You can also help take on a defensive case. This takes about 1 to 2 months. So when a client receives an unlawful detainer or an eviction, there are often defenses that they have, such as habitability issues, discrimination, things like that. But that takes a substantial amount of resources. So with your help, we can often do more than just assist a client in filing an answer to an unlawful detainer, and we're able to provide a more substantive defensive case. So this is another great way that you can assist clients and tenants preserve their housing.
Additionally, there are opportunities for affirmative cases, and those can take 6 to 18 months. They can go through the discovery phase, they can go through mediation, they can even go to trial potentially. And those cases often involve after the fact cases where a fraudulent eviction has happened. We had one where a client was forced out of their home by what's called a self-help eviction, which is illegal in California. And pro bono counsel assisted with that case that ultimately achieved a settlement. Also, numerous cases of owner move-in where it's been clear in East Palo Alto, for example, under the law that the owner did not move in as they had attested initially. And so those cases have reached settlement, and we've done over a half dozen of those, all with pro bono counsel over the last 5 or 6 years. And that's been wonderful as well. And we're deeply appreciative. So affirmative cases, again, very different timeline, 6 to 18 months, as opposed to defensive cases, which move very quickly. And Jackie just talked about, which just take 1 to 2 months. Next slide. Also, you could get involved with some of the advocacy work. We get asks for data collection or to aggregate data that's out there around potentially code enforcement actions or around different types of evictions. And it's also possible. So when we get those, our capacity, I should say, certainly right now, and generally it may be limited to be able to do that kind of research, but it may be the kind of research, both original research and aggregating other research that could really, really assist us and advocates that are asking for our help. Likewise, in terms of policy research, we often do contribute to the policy conversation. We write memos for other advocates, or we write letters that may go to city councils, things like that. But sometimes the issues are tricky and complicated and may require some additional research, or again, reviewing the literature statewide or even nationwide to provide some additional input. And so if that's the type of thing that sounds interesting to you, we haven't made as many calls for that in the past, but we certainly think that there could be opportunities in the next year or two for that. And I think with that, we will end our formal presentation. Yes, and have an opportunity for questions.
Yeah, and it looks like we do have a question, Keith, and this might be a good one for you. The question is, my understanding was that TPA does not apply to condominiums. Would you mind confirming or clarifying?
Yes, so actually yes, it's a great question. I believe that there are exceptions to condominiums that are rented in certain situations, but what I'm unsure about the moment, without having to look into the law specifically, would be if there's a certain number of units in a building, that type of thing. There are a lot of other exceptions small exceptions that we didn't get into. For example, if the landlord and tenant live together, that type of exception is usually going to be present in the law and in the TPA, and some others as well. And so, of course, it requires, in any case, an analysis of the TPA to an application of the TPA to the individual client's factual situation. So, I don't want to speak to the exact condominium situation because I don't know the answer, don't have it at my fingertips. But it is a trigger. If I heard, let me say it this way, if we heard condominium, certainly that would be a trigger for us to do a deep dive into the law and see how it may or may not apply to that situation. And there's other situations that would trigger us as well in that regard. So great question. Thanks for that. Don't have a firm answer, more of a issue spotting type of thing, hearkening back to law school.
Yeah, I'll give it a second to see if we have any other questions. Otherwise, I will shift over so that everybody could have our contact information. So Keith and I are both available to answer any questions that might come up after this presentation. And you'll see here our email addresses where you can reach either one of us. I don't see any other questions, so I will hand it back over to Patricia.
Thank you very much. So as this webinar comes to a close, I want to express gratitude to Keith and Jacqueline for providing us with great insights into tenant rights in our local communities, and to thank you as well for participating in the webinar and for your questions. And just a quick reminder that if you want to claim your MCLE credit, you need to use the link that I just put in the chat, and it's also on this slide. And I'm just going to say it quickly because it's a tiny URL. So if you just put tinyurl.com/YN54HVRW, you'll get to a form. It's a quick form, and then we'll be happy to launch you into the process of getting your MCLE credit for this webinar. So on behalf of Community Legal Services in East Palo Alto, happy Pro Bono Week, and thank you all very much for joining us today.